All right. Thank you so much, JNUTA Initiative, for organizing this discussion. The first on this book and first of any book that I've written. So I think this is really a very solemn occasion for me that my book is being discussed by JNUTA Initiative. Thank you very much, Akhil, for being here and finding time from your very busy schedule. And as Pia said, who could be a better person to discuss this book than you, and whatever gaps exist in my book, particularly on a region that I don't know as well as you, I hope you would fill that in. And in case of any errors, you would be kind enough to tell me what those errors are. So this book is about a law, a particular kind of law. So one of the things that I've done in this book is to think about ways of looking at law itself. When we talk about law generally, within those of you who are from political science here, law is generally seen as within the Austinian framework as the command of the sovereign. But there are ways in which distinctions are made in terms of where exactly the command is coming from, whether the source or the authority which is issuing the command is actually an authority that's competent to do so, and then a further standard of recognition where the what is the moral universe and questions of justice that law must actually satisfy in order for being something that people will feel obliged to obey, rather than obey because there would be penalties that would follow non-compliance. So when I think about the citizenship law, and I think about the choreographed exhibition which was on display on this screen a little while back, I think about the ways in which people were saying that they do not think that they can obey this law because there's something really unjust about not just the way in which the law was pushed through and made enforceable, but also because they don't feel that it is a law that they should be obeying as true citizens. And one of the things that I always find extremely interesting about laws is how they steep into our lives. They seep and saturate our lives and become invisible through such saturation. But they are also, in the process of saturating us, estranging us from our life worlds. And one of the stories that I feel really interesting in terms of understanding what one could call both the proximity and estrangement from law is a story by Saadat Hasan Manto, and this is how I start the book. And I talk about this story where, and I read this bit of passage. Malarika, I'm using the reading time now. So, amidst the violence that accompanied partition, the governments of India and Pakistan, which disagreed with each other on most things, agreed to exchange their lunatics. In a powerful story about how this exchange unsettled the lives of lunatics living in asylums, Saadat Hasan Manto wrote of Toba Tek Singh, a place name which became synonymous with a person and eventually became a trope for forced movement across the freshly created borders. The refusal of Bishan Singh or Toba Tek Singh, the man who stood on his feet for 15 years, to be transported to India was not taken seriously by officials on the Wagah border. No one could unequivocally tell him where his village was, in India or Pakistan. He was a harmless old man and confused in mind, they thought. Bishan Singh died an anguished death in the no man's land between the two countries. Another inmate of the same asylum climbed atop a tree, completely clear in his mind that he did not want to live in either country. He was going to make the tree his home. Yet another inmate, a person with an engineering degree, an otherwise pensive man, in the habit of taking long walks by himself, was so perturbed by his prospect of being allotted one or the other country that he took off all his clothes and shorn of all identifying accoutrements, ran into the garden. In another August, about 41 years before Manto's Toba Tek Singh refused to be transported to a country not his home, Indians in another country, fully conscious of the consequences of their action, refused to submit to a law that they considered immoral. The law in question, Registration Act of Transvaal, 1906, required all Asiatics, including Indians, to register before a designated registrar, submit their fingerprints, and acquire a registration certificate. Mohandas Karamchand Gandhi, I have left out certain sections, a lawyer who would transform civil disobedience into an art and make it an integral part of the war of positions in the struggle for national liberation in India, tried out and perfected its subtle skills and strategies in South Africa. Writing about the jail-going resolution in the Indian Opinion as a game of chess, Gandhi countered a cartoon that had appeared in the newspaper Star. The cartoon in Star depicted the Registration Act of Transvaal as a chess move initiated by the White Knight against the Black King to push it into a vulnerable position. Gandhi reproduced the Black King to push it into a vulnerable position. Gandhi reproduced the Star cartoon in the Indian Opinion along with his own response to it in the form of another cartoon. In Gandhi's cartoon, a black pawn representing the jail-going resolution was stationed strategically in a square, guarding against any possible move by the White Knight to checkmate the Black King. So the question about the justice of law and justice and injustice of law is something that I thought both the narration of Toba Tek Singh and the question of jail-going resolution and perfecting the art of civil disobedience by Indians in Transvaal was something very relevant to the things that we would perhaps discuss in the next 1.5 hours. Now, one of the arguments that I'm giving in this book is about how when one looks at the way in which the law on citizenship has evolved in India, one can see the law in terms of something that is structured in and produces specific kind of regimes. And why do I use the idea of a citizenship regime? When one talks about a citizenship regime, the idea is to go beyond what would be the bare facts of law. The precision in categories that law uses, go beyond that and look at the way in which political and ideological notions and the field of power within which law is located. What are the ways in which the state acquires the authority to make that law, and what kind of practices of justification are then put forward to say that this law must be enforced. So when one talks about regimes of law and talks about citizenship regimes, one is talking about the different ways in which the law as it has evolved over a period of time represents specific kinds of regimes. And these regimes, I would argue, are consecutive regimes. Now, each regime is in some senses discrete. One regime can be seen as around the founding moment of citizenship in India, and one could, and I would perhaps describe it as the moment of the transformative. And the transformative is where the republican and democratic notions of citizenship were being presented in institutional spaces like the Constituent Assembly. And I've gone in my book into the debates in the Constituent Assembly in a lot of detail. And one of the things that I argue about this idea or this context of the transformative is how, while discussing citizenship within that authoritative space of the Constituent Assembly, what was being discussed is the norms and principles which would make a specific idea of citizenship justiciable. And the reason I make that argument is because the way in which both the Joint Parliamentary Committee that recommended that the Citizenship Amendment Act must be discussed in Parliament. And much of the debate in the Parliament in 2019 was about what was it that Ambedkar said in the Constituent Assembly, where he said that the laws that we are making right now on citizenship are impermanent. They are ad hoc laws. And the Parliament, future parliaments, will have the authority to make new laws, and when they make new laws, they can base those laws on entirely new principles. So that is something that JPC was constantly talking about, and that is something that also became something that the debates in the Parliament were also focusing on, to say, no, this is not what we are saying. No, this is what was said by Ambedkar in the Constituent Assembly. And one could see within the Constituent Assembly that there was something like what one could call a kind of an agonistic policy, where people agreed that even when they disagreed on what the principles around citizenship would be, or what the idea of citizenship would be, there would be a deliberative consensus that can be arrived at. And this deliberative consensus was based on how the Constituent Assembly decided that they would agree on procedures. So even when the draft of the citizenship provisions was finalized by the drafting committee, and members of the drafting committee did not even agree with each other on what that draft would be, when the provisions were brought before the Constituent Assembly, the members of the drafting committee came out in open about their discomfort with the provisions of citizenship provisions. And here, Nehru, deviating from what Ambedkar had said it's not the task of the Constituent Assembly to frame laws. This is something that the Parliament would do in future, but we are here to lay down the principles. And these principles would be important because no future Parliament can then deviate from these principles. And a lot of debate was around laying down secularism as the principle of citizenship. And the fault lines in the debates were such that even when there was a strand of opinion that would say that birth should be the defining principle of citizenship, they would still want to make birth dependent on lineage and descent. So what I'm trying to say is that there was no clear-cut division in terms of whether birth or whether descent should be the organizing principle of citizenship. What was, however, decided and conclusively agreed upon through debate and deliberation in the CA was that secularism was to be the basis of citizenship as a principle that no future Parliament could deviate from when they make a law on citizenship. And in case, and this is something that came up in the discussions, in case a deviation happened, then that would be considered as an amendment of the Constitution. So if we were to think about the ideas of citizenship in the founding moment, and the idea of the transformative that structured that moment, constituting one particular regime, this regime changed in the 1980s when Assam was accommodated simultaneously as an exception in the citizenship law. So if we were to think about that as the second regime of citizenship, and the accommodation of Assam as an exception that kind of continued through 2003, when an extraordinary procedure for framing NRC for Assam was laid down in the citizenship rules of 2009, following the amendment in 2003. So the Assam exception and exceptional regime of citizenship is what I would call the second citizenship regime. A third citizenship regime is the contemporary regime of citizenship, which I would say emerged out of the 2003 amendment. And 2003 amendment, I would therefore say, was the hinge point from where two distinct and perhaps dissonant tendencies emerged. One of the tendencies was the NRC, where 2003 amendments laid down for the first time that the government of India, if it wanted, did not have to, if it wanted, it could prepare a national register of Indian citizens. And now when it prepared a National Register of Indian citizens, now it, as we know from the experience from Assam, it put in place something like, an innovation was innovation in terms of legacy, and legacy traces, legacy data, so that the idea of descent was in some ways descending from lineage, which could be traced to a moment that was decided in the modalities of preparation of the NRC. So the coming together of birth and lineage happened with the 2003 amendment and the provisions for the preparation of the NRC. In the case of Assam, it was not a preparation of the NRC, it was an updation of the NRC, because that's the only state, undivided Assam, where the 1951 NRC was prepared in a context where the 1951 census was being prepared amidst communal violence and the mobile populations across border, without the kind of bureaucratic apparatus that one sees or one saw in existence when the NRC was prepared in Assam in 2015-16 onwards. So the second trajectory that I would point out is the trajectory where citizenship by birth was constrained in 2003 to make it contingent on blood and descent. So you could be a citizen of India only if one of your parents was also a citizen and the other was not an illegal migrant. So the category of illegal migrant made its appearance for the first time within the provisions of citizenship by birth, and also within the provisions of citizenship by registration, so that an illegal migrant could not apply for lay claims to being a citizen of India. Now, what the 2016-19 amendment did, and this is where I feel that the 2003 amendment becomes extremely important, because the 2019 amendment laid down the exceptions to the category of illegal migrant which was put in place in 2003. Now, which is then to say that people who would be considered illegal migrants under the Foreigners Act and the Indian Passports Act would be exempted from any kind of penal action, and then they would be eligible to apply for Indian citizenship. Now, the CAA, I would argue, and the NRC and CAA, I would argue, in this contemporary context, have become conjoined in the two dissonant categories that I thought were earlier. Now, one laying down that there is a way in which illegal migrants can be identified for deportation. Second, the CAA as exemptions to the category of illegal migrants, they become conjoined in a context where the CAA is laying down a condition of what one could call bounded citizenship. Lay down walls of separation, boundaries that could encompass a community, and a community in which the state can territorialize its authority, and not just territorialize its authority, but mark the population in a particular way. And in this case, the CAA was, one could say, was hiding behind the veneer of liberal citizenship, saying that these are citizenship rights are extremely important, because it's not just a status that you have, but it's also consequential. Because you are then eligible to other rights, and which would then have ramifications for rights of others. So it's not just your right. It's right about, it's relational and consequential. Your status is consequential for rights of others, not just your rights. So the entire, if you were to read the statements of objects of the CAB, the statement of objects would kind of appear to be protective of religious, it doesn't anywhere actually, the Act never ever actually anywhere say that it's protecting religious minorities. It just says persons belonging to, and then names the communities, identifies communities by religion. It does not say that it's protecting religious minorities, but identifies them through religion. So while the CAA is claiming to be protective of people discriminated on the basis of religion, it actually itself discriminates on the basis of religion. So what is the organizing principle for putting in place what one could call a protective regime? The CAA can be seen as itself being discriminatory on the basis of religion, and that's written in law itself. The coming together of CAA and NRC is also not simply in terms of the fears and anxieties that are expressed in the protests against the CAA. The NRC is also about a kind of citizenship that takes recourse to the idea of lineage. So it's if you were to recall the entire process of people presenting themselves to the authorities for enumeration as citizens, that a place on that role, the NRC as citizens, they are expected to put in place documents that they proves their lineage to somebody who was a citizen or resident of Assam between 1951 and 1971. So trace your legacy to that legacy data, and not just to that legacy data, but also to a whole lot of people who would be connected to you because through that number of legacy that is that's given to you. So in some senses, if you were to think about the NRC as a process, the NRC is, and this is an argument it's a powerful argument given by Ranabir Samadar, who says that the NRC is in some ways arresting the power of the family to absorb their awkward elements. And I'm thinking about other writings on partition by people like Veena Das, who talked about the different ways in which family figures in partition, where the family is not just complicit in the way in which the state wants to pluck out people and put them in institutions to make them citizens who would be productive within the space of the state, but the family also makes these citizens inscrutable to the state, so by absorbing them. Now, what the NRC does, it makes not just arrests the power of the family to isolate and insulate, it also uses individuals who constitute the family to make the entire family suspect. So the NRC is the coming together of the CA and NRC in one sense with the CA by a notion of bounded citizenship, and in the case of NRC as a citizenship based on the power of or the evidentiary worth of documentation, which Kamal Sadiq has pointed out in his book. These coming together created in the contemporary landscape, the conjoinment of these two tendencies created in the contemporary landscape of citizenship, a fear around the idea of citizenship itself. Now, and I'm saying that the idea of fear is extremely important, and here perhaps I would use my other 5 minutes to talk about fear in another art installation. Considering that I'm here with people who deal with art. Okay. So I'll read from here. The original constitution has been resurrected in installation and live art performances in which the Constitution as a body of law has found expression in spatial and embodied experience. Summoning the historical form of the Constitution in installation art to recall it in a contemporary space replete with vulnerability, Riaz Komu's art exhibition, Holy Shivers, gave form to emotions of fear, of the violent present and the uncertain future, and of hope in the weight of the promises made in the past, by invoking symbols from constitutional calligraphy and those that have become part of the narrative of India's constitutional democracy. Komu's installations took the form of a political critique of human aggression, Como termed this aggression militant enthusiasm, an instinctive component of human psychology to wreak destruction for a fictional cause. In an innovative use of mirror imaging as a concept to represent reflections and images as an aspect of reflexivity, Como set up digitally scanned original pages of the Constitution in collocation with X-rayed images receding into darkness to evoke an imagery of what was being lost amidst the violence. In an evocative framing of Dhamma Swaraj through the juxtaposition of Ambedkar and Gandhi's portraits in successive panels which blend into each other and eventually appear inseparable, Como suggests the relevance of both in tandem instead of unbridgeable binaries. Como explained the juxtaposition as follows. Dhamma Swaraj is an overlapping triptych portrait of Gandhi and Ambedkar that explores the interaction between two apparently disparate ideologies in the scope of a single frame. The figure of Ambedkar on a pedestal supported by iron legs, unusual for Ambedkar's figures that have taken a modular form, is without a copy of the Constitution in his hand and not instructing nor showing the way forward, but raising both his hands in a gesture of reasoned argument. The representation presents the possibility of a dialogic space around the Constitution which produces communities driven by a different moral order, that is, of public conscience bound by empathy, that makes the alleviation of human suffering its primary concern. I think, Malarika, I'll stop here and I'll have Akhil come in.
Should I?
Yeah.